Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation? What if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens, and they said this is the worst offender and we're going to require divestiture by this offender? Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you posited.
Well, you're changing that. You're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like ACARA, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law. It didn't go after speakers at all. If you had a law in ACARA that said we're going to prohibit prostitution in bookstores only, then I think that ACARA would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict.
All right. Well,
that's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed for the purpose of narrowing in on what your argument is. I understood you to say that that would not be a solution to the problem because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that that would trigger, at the very least, intermediate scrutiny.
All right. Thank you.
Justice